Thanks, Jen. I might have to take my camera off at some point because my internet's not great. Yeah, afternoon, everyone. Can we just move on? I think 2 slides, is it? Yep. And the next one. Lovely. So what's on today's agenda? Well, as it said in the heading, we're looking at protection that clients or employers, as we call them under NEC, require from main contractors. Some of these issues also pass down to subcontractors, depending on the size of their work scope and the value. So you can see from the long list there that there is a substantial amount of added security that employers take. And I think if you're new to construction, I think it's worth noting that, I don't think there's any other industry or sector where the paying party takes so much security. So we're going to be looking at a few things that have slightly strange names if you're not familiar with them. So collateral warranties, retention, which I expect you will all be familiar with, but I've included that and delay damages further down, just so we've got the whole ambit of the additional security. So we've got retention. We've also got these strangely named parent company guarantees and performance bonds, delay damages, as I've said. We're also going to look at contractors' liability for design, X15, and also limitation of liability X18, both under NEC. Now, they are not security for the employer. In fact, they're the opposite. They are protecting contractor and subcontractor in a subcontract. But, it'll become apparent why we want to look at those. And finally, we're going to look at clause 50.3, which is sums that the paying party can retain if the contractor or the subcontractor in a subcontract doesn't submit its first programme on time. So if we can move on to the next slide, please, Jen, and onto collateral warranties. Very strange name. So what is it? Well, basically, collateral warranty is a contract. It's an agreement. There's nothing too special about it. Whilst I'm going through this, if you can think of the contract supply chain for a design and build contract, which is very linear. So it goes from, possibly from funder, who funds the project and gives the funding to the party commissioning the works, the developer or the local authority or hospital trust or whoever's having the work carried out, who then passes the money down to the main contractor. Typically, in this country would be on a design and build contract, and then the main contractor engages various subcontractors and various consultants, engineers, architects, etc. And the subcontractors might engage their own subcontractors, and at some point in all of that chain, contractor and subcontractors and subcontractors will be engaging suppliers to supply materials and, of course, plant. So you've got a chain that sort of goes from top to bottom. And that's basically if there are any problems with either the build, quality, or payment, how the proceedings run, i.e. from one party to the next. So this is effectively called privacy of contract. So if you have a contract with another party, you both have rights and obligations in regard to each other. But the privity part is that nobody else has rights and obligations. It's just the two parties to the contract. So the scenarios that we need to think about in construction, and which is why we have collateral warranties, are, for example, contractor goes into liquidation partway through a build. That leaves a big gap, both literally and metaphorically, in the whole process. The developer is going to have to work out how to complete the works. So that's the gap they've got to fill. but the people at the other end of the supply chain, subcontractors, consultants, have got a gap in the work. They're not going to do any more work because their employer is insolvent, so isn't going to pay them. So you've got a gap there. And of course, common sense says the best way to deal with that would be for the party commissioning the work to approach the current team, the consultants, the subcontractors, and get them to finish the work. So that's, we're sort of thinking about that scenario. And also a scenario where, so again, typical is the build has been completed possibly for a couple of years. The party who commissioned it still owns the building, and they find some substantial defects, for example, in the roof, and thinks, all right, that's not great. We need to bring some proceedings to recover the cost of remedying that defective roof. So under a design and build, that party would normally look to the contractor to recover that money. And that's one of the advantages of a design and build contract, the party commissioning the work. It's a one-stop shop in terms of recovering claims in this regard. But again, what happens if, since the build has been completed, that main contractor has gone into liquidation? Now, ordinarily, sort of a layperson might think, well, it just makes sense. The party who's commissioned it, surely they can just bring proceedings against the subcontractor or the consultant or both, whoever has caused this defect. Well, the answer is no, because of the privity of contract rule. You only have obligations with the party you've contracted with, and the party who's commissioned the work in this instance hasn't contracted with subcontractors or consultants. So again, collateral warranties are aimed at plugging that gap as well. So what it is another contract. So second bullet point, it's entered into between the employer, the beneficiary, and the contractor, subcontractor, consultant. So there's a flow chart of all the sort of possible variants in terms of collateral warranties. But if you've provided them on a project, whether as a contractor or a subcontractor, you may have found that you have provided them to. So as a subcontractor, you may have provided them to the party commissioning the work. So, the employer or the client, a funder, possibly subsequent purchasers. All of these would be called the beneficiary, as it says in that second bullet point. And as it says at the bottom bullet point, the purpose is to create a direct contract link between the people who don't ordinarily have a contract link. And again, there's a chart later on that kind of shows that in more graphic terms. So if we can move to the next slide, please. Thanks. So we've got two things. Very generally speaking, we have two forms of collateral warranty. We have various industry standards. So in the way that we have a JCT, design and build contract, we have the various NEC contracts, they're industry standard. We also have industry standard forms of collateral warranty. They're not particularly well used. Generally, they're more favourable to the party giving the collateral warranty to the party providing it. So contractor, consultant, subcontractor. So you can see why they're not well used. We also have what we would call a bespoke collateral warranty. They're all kind of pretty similar, but generally they have been prepared by one law firm or another. And sort of adapted and used by people. And generally, they're prepared when the general Z clauses are being prepared to the main contract, or when the JCT contract particulars are being schedule of amendments, is being prepared. So generally, it's put together as a package. So you get your contract and also the collateral warranties appended to it. So they're the two types that you'll get very roughly. Oh, can we just go back? Sorry, Jen. Yeah, that's it. So two other points, just very high level. When you are reviewing your contract, if it requires you to provide collateral warranties, that form of collateral warranty should be appended to the contract. If you send it to your insurer, particularly your professional indemnity insurer, they may well review it and provide some favourable amendments that you can run past your client. You often get a better chance of having those amendments agreed if they come via your insurer. And also, contractors when stepping down a contract to, contractors when stepping down a contract to their subcontractors will also, if they're required to obtain collateral warranties from their subcontractors, they will need to include the requirement for warranties and also the form of warranty within the subcontract. So again, subcontractors, when you're reviewing your contracts, feel free to get your professional indemnity insurers to check them. Now, historically, collateral warranties have been used predominantly where contractor or subcontractor, whoever's providing the warranty, is carrying out some design work. What we're seeing more and more, probably, I don't know, post-COVID, I think, is collateral warranties just being used whether or not there's any design responsibility. So in other words, it's aimed in some cases at just covering workmanship where the contractor or subcontractor isn't carrying out any design work. Next slide, please. Yeah, so just some basic checks first of all. So your requirement to provide a collateral warranty, whether you're a contractor, a subcontractor, or a consultant, is dependent upon what your contract says. So this is the contract for you to carry out the works. So if your contract contains no reference to any collateral warranties, no collateral warranty appended, and you are asked to provide one, you have no obligation to provide one. You can refuse. What you might do is say, well, I'm willing to consider it, but it will be an extra price because it's not part of my contract sum. But fundamentally, you're not required to provide the warranty. So, that's always the first thing to check. Also check who are the beneficiaries. Who are you required in your contract to provide the collateral warranty to? So typically, if you're a subcontractor, you'd be required to provide one to the employer. Ditto if you're a consultant. The main contractor doesn't need to provide one to the employer because, of course, the main contractor has a direct contract with the employer and vice versa. All the construction parties may be asked to provide warranties to funders because none of them have a direct link to them, to end users, and also to people purchasing the property. So typically a developer might build a block of offices and then sell it on to a fund to a new purchaser. So typically it would be an investor. And in that case, they would want a collateral warranty for the example where there are defects discovered subsequent to completion. And also tenants, if they have a repairing covenant lease. So there's a whole raft, so just be aware of that. And then finally, check how the collateral warranty obligations compare to the contract obligations, because whether you are the main contractor, the subcontractor, or the consultant, what you don't want to end up with is a collateral warranty that puts more obligations or greater obligations on you than your contractors. Because basically your contract is what you are pricing for. So if we can move on to the next slide, please. Yep. So your collateral warranty, as I've already said, will be drafted and appended to the contract. So you should get a chance to review it before you agree to sign up to your contract. And if you're not happy with the terms, you should be asking for amendments there and then. Sometimes when you sign up to your contract, it may say you're required to provide a collateral warranty, and you can request amendments. And the party who is going to be given the collateral warranty must accept any reasonable amendments. But of course, that only gives a very limited right to very limited amendments. So, if there are any substantial amendments, you really need to make them before you sign up to the contract, because when you sign up to the contract, you are agreeing to provide that collateral warranty. Second bullet point, if you are a main contractor, your contract will also likely require you to obtain collateral warranties from your subcontractors and your consultants, probably on very similar terms to the terms that you are required to provide collateral warranties. Also, the penultimate bullet point, there will likely be, as there always is in contracts, a time limit for providing them. So for both in a main contract, the main contractor providing collateral warranties, but also a time limit for the main contractor to obtain warranties from its subcontractors and consultants. Very often as well, there's a clause that says if one of the parties doesn't comply with the time limits, then there is a financial penalty. Sometimes if it's really harsh, it'll say no money will be due until the warranties are provided. Other times, as in this example, it might say there'll be a 10% deduction of all sums due until the warranties are provided. Either way, it's not great having a deduction, because somebody's been surprised by a request for warranties and is delaying providing them. If you are a main contractor and your contract requires you to obtain warranties from subcontractors and or subconsultants, then obviously you need to include similar clauses in your subcontract so that you have imposed on the subcontractor and consultants a contractual obligation to provide the collateral warranties within timescales, etc., etc. Next slide, please, Jen. Okay, so how do the contracts, JCT and NEC, deal with this? Well, so we've been talking about collateral warranties. So the collateral warranties in NEC, third bullet point down, NEC 4 covers them at option X. Bizarrely, it's called undertakings to client or others. But you just need to bear in mind that is essentially a collateral warranty requirement. So when you're reviewing your contracts, look out for X8 and you'll know what it's about. Next bullet point down, the contract NEC 4 states that the collateral warranties are located in the contract conditions of the NEC, and actually it will be included, the form of the warranty will be included in the scope of works. Also be careful with NEC because clause 91.2, so these are the termination provisions, states that the project manager can terminate the contract if the contract doesn't provide the warranties within the set time scales. So not great news. I mean, typically that wouldn't be used to terminate. You would more likely have the financial penalty imposed. But where it might be used is if something else is causing problems on the project, and one of the parties, so the party who hasn't been provided with the collateral warranty within the timescales, thinks, right, well, I just need to get this contract terminated. It's not working out. How can we terminate it for default by the other party? So they're the NEC requirements. So if we go back to the first bullet point, why UK3? So this is the third party rights. So this is an alternative to collateral warranties. So we've seen collateral warranties, hopefully you'll have realised if you haven't dealt with them before, it's quite a cumbersome arrangement, having different collateral warranties appended to your contract, having to have them executed by lots of people, having to provide numerous warranties for different parties, having to get them for your subcontractors. So the Third Party Rights Act was introduced, probably about 15, 20 years ago. The idea being that within your contract, stroke subcontract, stroke appointment, if you're a consultant, you can include a clause pursuant to the Act and say, we all intend that in this subcontract, the subcontract will have obligations to funders, purchasers, and all of those third parties, whichever apply, under this contract. So you're basically putting a clause in your contract to say third parties can benefit from it. So if the collateral warranty is a contract to get around the privity of contract rule, this is a clause that goes into your contract that basically gets around the privity of contract rule and allows other parties to benefit from the obligations of contractor, subcontractor, consultant, whichever contract we're talking about. Bottom bullet point is the JCT provisions 2011 and 2024. So Section 8, Schedule 5 contains TPR third-party rights as one option, and as an alternative, the collateral warranty options. So next slide, please, Jen. Yep, so this is just about the mechanics of NEC4X8. So by the way, if you're on an NEC3, what you will find is that collateral warranties will typically be dealt with in the Z clauses. So X8 was introduced with NEC4. So the contract data part 1, so this is the bit that the client, the paying party, completes, states who the beneficiaries are. Is it just funder? Is it funder, prospective future purchasers, future tenants, etc. The next bullet point, so X8.2, specifies whether the contractor has to provide collateral warranties from subcontractors, most likely, particularly if they're designing, but not exclusively so, and ditto from the subcontractor to the employer. Penultimate bullet point confirms, so X8.4 states that the form of the collateral warranty is included within the scope of works. And then finally, the time scale for executing the collateral warranties is within 3 weeks of the client, the party requesting them, sending them to the contractor. So if we can move on to the next slide, please. Okay, so we've so far spent some time looking at what is a collateral warranty, what does it do, and also when are you required to provide it if the requirement is stated in your contract, and how do you know what form you've got to sign up to? Well, you sign up to the form that's that you have agreed and signed up to and is covered in your contract or subcontract. We also looked at the standard forms where there's industry standards and also bespoke. And I said that the bespoke forms lawyers have prepared, and they're all actually amazingly similar. So typically there'll be about 8 pages, but the key pages are sort of probably the first 8 clauses or so. So this kind of sets out the key clauses that you would expect to see. So I think there's probably about 8 of them. So generally the first clause is kind of duty of care. So it's around, so this is about design. So the design skill, will be stated as being reasonable skill and care. So we looked at this last month. will not be, or it should not be, fitness for purpose, because that is too high a standard. There's no PII cover for it. And if you remember, last month we looked at the professional services contract and also the design, build and operate contract, both of which have reasonable skill and care as a core clause. In the engineering and construction contract, it's X15, which is why we're covering it later on today. So it should be reasonable skill and care. It'll be words like that. What you don't want is fitness for purpose, or will will be fit for the purpose that it's designed, etc. So it's basically around the contractor stroke subcontractor, whoever's providing the collateral warranty, will carry out the work reasonable skill and care. The next one, deleterious materials, they won't be used. They'll probably be listed. You see a similar clause in your main contract, your subcontract. Insurance, professional indemnity insurance will be covered here. So all of these clauses are sort of mirror clauses to clauses that you will be signing up to in your main contract, subcontract or consultant's appointment. So the key is to make sure that none of these clauses give a greater obligation to the contractor, subcontractor or consultant. It should all be the same obligation or the same level of obligation as is contained in the underlying contract. The step-in rights, we will deal with that later. That's unique to the collateral warranty. Copyright, again, that will be in your contract stroke subcontract. It needs to mirror that clause. Assignment simply allows, it's predominantly used, so it allows one party who is the beneficiary under a collateral warranty to assign the benefit to someone else, basically to pass it to someone else. So typically that would happen when a funder, in the same way as mortgage terms come to an end, and the party obtains a new mortgage, sometimes with a new provider. Same things happen with funding in commercial premises. So in that case, the old funder, their loan has been redeemed, so they don't need the collateral warranty anymore. They have no interest in the building. If there are defects, it's of no matter to it. So it can assign the collateral warranty to the new funder, so that the new funder has rights to pursue a claim if there are any defects during its tenure. And then the key clause is limitation of liability. So this is basically that if you have limited your liability in any way within your main contract stroke subcontract stroke consultant's appointment, you need to make sure that that is reflected within your collateral warranty. What you do not want to happen is, for example, a funder to pursue a party for defects where in their contract they've limited or capped their liability, and then the funder says, well, this collateral warranty doesn't say anything about that, so there's no cap here. So I think if we can move on to the next slide. I'm hoping there is, yes, there's an example clause. As it says at the start of the slides, this isn't a substitute for getting your own legal advice. This is just an example of a clause. So for example, it is immediately flawed if you're a subcontractor because it's working on the basis of a contractor. Also, it's flawed if you're not. So if you're on an NEC form of contract, it doesn't use the term building contract, which this clause uses. So don't rely on this. But what you would expect to see in the collateral warranty would be a clause similar to this. So it's divided into two. So the first half is basically saying that the party giving the warranty, so contractor or subcontractor or consultant, owes no greater duty, obligation or liability to the beneficiary, so that could be the funder, the new purchaser, etc., which is greater or of longer duration than it would owe to that beneficiary if the beneficiary had been named as a joint client with the employer under the building contract. So it's a sort of negative in that it's protecting the contractor from having any greater liability. The second part of the clause, where it says, and the contractor shall be entitled in any action or proceedings by the beneficiary to rely on any term in the building contract. For that, you substitute main contract, stroke subcontract, stroke consultant's appointment, and raise the equivalent rights in defence as it would have against the beneficiary under the building contract had the beneficiary been named. So it's basically saying this is a positive obligation. The contractor or whoever is using this clause can rely on anything in its building contract by way of defence to the beneficiary as if the beneficiary had been a party to the building contract as well. So that's one of the key things, as well as checking that the other clauses that we looked at don't give contractor, subcontractor or consultant a greater liability. This kind of clause is needed to ensure that you do get the protection of any limitation of liability, any cap on liability into the collateral warranty. So next slide, please, Jan. Okay, so the step-in rights. So this quite nicely shows the sort of contract structure. So if we look at the sort of the boxes in the middle, we've got funder and employer contract with each other. So this shows privity of contract. They have contractual rights towards each other. Employer and contractor contract with each other, rights and obligations between each other. So the funder has no connection to the contractor in that chain. So funder can't sue the contractor and vice versa. And then, of course, you know, in our usual contract chain, we've got the contractor engaging consultants and subcontractors. So the arrows going up the slide are the collateral warranties, actually say CW. So these are who gives the collateral warranties. So for example, you can see that the contractor gives the collateral warranty to the funder, but no one else. Doesn't need to give one to the employer because there's a contract between them. Whereas you can see on the right, the subcontractors give collateral warranties to the employer, don't have a contract with them, and the funder ditto. Step-in rights are included in the collateral warranty, so it's usually kind of probably about a substantial part of the collateral warranty, probably a page and a half. And it's generally to cover a termination scenario. So in this scenario, the contractor is terminated, possibly because it's gone into liquidation. Doesn't have to be, but let's run with that example. So particularly if you're partway through the build, employer needs to finish the build, consultants, contractors possibly want to keep building for cash flow. So effectively what would happen would be that the employer would step into the contractor's shoes and effectively become the contractor, or appoint a new contractor to do so. So then you've plugged that gap, you get the build finished, and effectively the new contractor or the employer who's stepped in takes over and obviously pays the consultants and the subcontractors for the work they do. Usually there is also a requirement in the collateral warranty step-in rights. It has got to be in there. So if it isn't, it doesn't apply, but usually it is. And it says, particularly if a contractor is insolvent, if the employer steps in to the contractor's shoes, then not only has it got to pay the consultants and contractors moving forwards, but it's also got to pay any outstanding sums that have become due. So that is really good for consultants and subcontractors. So, that is, an advantage of a collateral warranty. Now, in that scenario, there is nothing to force the employer to do that step in, and particularly, if the project, if the build is, all but finished, there's just a bit of finishing off work, then it might be the employer will decide not to step in. They might just decide to get new subcontractors on board, because it doesn't want to have to pick up all those historic unpaid fees, particularly because if you bear in mind in an insolvency, often what has happened is the employer has been paying the contractor in this scenario, and the contractor hasn't necessarily been paying its supply chain. So, it's a difficult position for both the employer and subcontractors and consultants in that situation. So that's how stepping rights work. It obviously works, so if example, the employer went into liquidation, then, the funder might step into the employer's shoes because of course the funder's invested money into the building, probably got security over it almost inevitably. And half a building isn't any good to a funder, so they will want to have it completed. So, it works across the chain. Next slide, please. Yeah, so we've covered that. That's fine. So the next slide. Yeah, we've covered that. That's fine. Yeah, I think we can keep going until we get to. Yeah, and the next slide. So these are the other securities. So the first one on our list was retention. I'm sure you all know about retention. It's an interesting one because I can't think of any other industry where you do work or you go to pay for something, and when you go to pay, you say, well, I'd like to take, yes, I'd like to buy that, but I'm only going to pay 95% of the price, and I'll pay you the rest at some time in the future. So that, worth bearing in mind. But NEC 3 and 4 both cover retention. So again, optional clause X16. If you're reviewing your contract before you sign it and you see that, you are going to be paying a retention. So again, the purpose of this is that for each interim payment application, employer stroke client or contractor in a subcontract determines how much is due, and then the contract allows it to make a deduction, typically of 3 to 5% in NEC. The percentage is stated in the contract data. If then, for example, contractor or subcontractor fails to remedy defects, something like that, then the party holding the retention will retain it towards the cost of the remedial works. Bottom bullet point, NEC 4 makes provision for a retention bond as an alternative. We're going to look at bonds in more detail. Just bear in mind that a retention bond, somebody will have to pay for it. So assuming it's the contractor getting the bond, because no retention is going to be deducted from it, so either the contractor or the paying party, the employer, will have to pay for the bond. The other point is that usually a retention bond will be on demand. So, if at any point the party who would ordinarily be keeping the retention, deducting it and keeping it, they can, on demand say, actually, I would like that money, and it's got to be paid. The final thing about retention bonds is that there seemed to be a real kind of trend to use them probably just before COVID and kind of whilst we were in lockdown. My understanding is that they're quite expensive now, and they're sort of, sometimes these things go in trends. They seem to be less fashionable at the moment. Next slide, please. Oh, yes. So the key thing is, I'm sure you're aware of this, generally speaking, and again, as with all contracts, it depends on what the contract actually says. But with NEC, it says that the client retains whatever percentage retention, so 3 or 5%, then 50% of that is paid back at completion, and then the balance is paid back at the end of the defects period. Next slide, please. Okay, so parent company guarantee, another kind of strange wording. So we're sort of used to, I suppose, in the context of parents and children, we're used to sort of guarantees in the context of quite often, young adults rent a property, and my understanding is quite often somebody has to guarantee the rent payments, and quite often parents step in and do that. This is just a very similar situation. So it's basically the parent company, or it could be a sister company of the party doing the work, can guarantee the work and liabilities of the company doing the work in regard to the contract. So if it's required under either NEC 3 or 4, it will be covered in X4, option X4. So if that clause is included, you need to provide a parent company guarantee. Now, obviously, if you're being asked to provide a parent company guarantee and your business does not have a parent company, then it can't provide it. So X4 states that the form of guarantee, so like a collateral warranty, it's sort of a separate contract that has to be signed by, in this case, the party providing the parent company guarantee, whether it's a contractor in a contract or subcontractor in a subcontract. They sign it, they execute it. Also, the parent company executes it, and also the party getting the benefit of it. So usually that will be the party commissioning the works, the developer, local authority, etc. Now, why might you want a parent company guarantee? Well, typically it is to protect against, well, not against, but it's to protect in circumstances where the party who's giving the guarantee, the party who is obtaining it, so the contractor or the subcontractor, the party carrying out the works, if they go into liquidation, it means that the parent company has to step in the same way as parents have to step in and pay the rent from for their adult children if the adult children fail to pay the rent. So the form, the sort of contract is located in the scope of the works information. So again, you need to read it, because I'm kind of talking about generally what you would expect to see, but of course with every contract, with every agreement, the key is in reading what it actually says. What I'm talking about here is just generally what I would expect it to say. So second bullet point, X 4.1 requires the parent company guarantee, if it is to be provided with at contract execution or within 4 weeks of the contract being signed. Now, there is a penalty for not providing it, as we saw with collateral warranties. The contract can be terminated, so just be aware of that. Under NEC, so this is the third bullet point, the ultimate holding company, it means that the parent company can step in to finish off the works and cover off any losses. Penultimate bullet point, the expiry of the parent company. So this is the same as a collateral warranty. So, well, collateral warranty is subject to any caps on liability in the contract, but generally speaking, they will be executed as deeds, both the collateral warranty and the parent company guarantee, which generally will mean that there's a 12-year liability beyond practical completion. So in my experience, if there is a parent company guarantee, it will not just give a parent company guarantee every time one is asked for. They will want to consider it, particularly because it is such a long liability. So the final bullet point is the time limits. If you don't provide your collateral warranty within those 4 weeks, then the project manager can give another 4 weeks. And if it's still not provided, can terminate the contract. So just watch out on that. Very similar to the collateral warranty. So next slide, please. Yeah, and that's just that so that's fine. Okay, so the next one is performance bond. Again, odd language. So quite often, historically, if you didn't have a parent company, so couldn't give a parent company guarantee, the contract would require a performance bond instead. So what's a performance bond? It's like a guarantee, really, but it's provided by a bank or an insurer. So typically, subcontractor wants a performance bond. It will approach its own bank for the bank to provide a performance bond, aka, guarantee any losses that the employer might pursue against that party. So clearly, will the bank just provide that? No, it's a commercial transaction. So the bank or the insurer, whoever provides it, will require probably a substantial payment depending on the value of the bond before they'll provide it. So under NEC 3 and 4, performance bond is option X13. So again, as with the others, if you see that, you know that you've got to provide a bond. Commonly, what we're seeing is a requirement for both the parent company guarantee and a performance bond on projects, because they've got different benefits. So, for example, the parent company guarantee, if the contractor goes into liquidation, it might be that the parent company follows, in which case the parent company guarantee, is of little value. With the performance bond, with the performance bond, typically the liability ends at practical completion. So that's a disadvantage compared to parent company guarantee, where the guarantee usually goes on for 12 years after practical completion. So you can see there are advantages and disadvantages. Also, third bullet point, typically a performance bond, the value will be 10% of the contract. So irrespective of the value of the losses that the employer claims, it's what they can be paid through the bond is capped at 10%. So, that would be a client and employer's argument for having both, that, they cover different scenarios. And yes, I think that's, so, and the other point, the second bullet point is, as we've seen before, the form, again, it's just another form of a contract to be signed by the 3 parties. So in my example, the subcontractor, the client, and the bond supplier. So the document, the form of the bond that's going to be executed between the parties will be in the scope works information. So if we can move on to the next slide, please. And yeah, finally, as with the others, clause 91.2, if the contractor doesn't provide the bond where they're required to, the project manager notifies the contractor of the default and can then terminate the contract. The employer can terminate the contract if the contractor still doesn't provide the bond. Next slide, please. Okay, so delay damages, I just wanted to include this because it is technically extra security. So it's basically if the contractor doesn't complete the works, then that's fundamentally by the completion date, then that's fundamentally a breach of contract. Damages and losses are claimable resulting from a breach. So client/employer is entitled to its losses. What we tend to do in construction, and this is X7 in NEC, is to liquidate those damages. So we set a figure so that rather than having to prove the losses at the time, the figure's set in the contract. Now that's an advantage for the party paying because they know how much they have to pay if they cause delay, they know in advance. But it's an advantage to the party claiming those delay damages because it means that as soon as there is any delay, they can start to levy, they can start to claim those damages. They don't need to prove how much they're entitled to before claiming them. So it is sort of another form of security. So as it says there, it's option X7. So it's generally used in construction contracts in my experience. If it isn't, then general damages will apply, which just mean that the party claiming the losses has to prove the losses, has to justify them. So the amount that's payable is set out in the contract data part 1. I think that's probably everything on that. And NEC 4, there's no changes, identical to NEC 3. So if we've got the next slide. Okay, so we said that we'd touch on X15. So this was in the context of that no greater liability clause in the collateral warranties. So this is just a reminder, we covered this last week. If under the engineering and construction contract, stroke subcontract, you are carrying out works where you have any design liability, you need to include this option X15. Most of the other optional clauses benefit the employer, the client, whoever's paying for the work, as we've seen. This is one of 2, I think, that benefit the party doing the work, and it's absolutely critical for the reasons that we've discussed. And I mean, I quite often mention this, but I wanted to particularly mention it here because of its relevance to the collateral warranty. If it's not in your contract, you might find that under your collateral warranty, you're liable for a higher standard than the reasonable skill and care because you haven't limited your liability at X15. So if we can move to the next slide, please, which I think, yes. So again, this is the other clause, not kind of top critical for the party doing the work, but always worth considering. So this is limiting or capping your liability at X18. So it's relevant to today because of what we talked about with regard to collateral warranties, no greater liability clause. Typically, you would also have similar provision in a parent company guarantee as well. So it sort of gives extra, I don't know, incentive for the party doing the work to try and get its liability capped or limited using this clause. So quite a nice clause. It gives a variety of ways, sort of pick and mix of ways of limiting and capping your liability. You can use all of them or a selection. So the next slide, please, which I think is the last one. So the final point to note is this tricky little provision. So clause 50.3. So this is all about the contractor submitting its first programme. Now, last month we looked at how critical the first programme was, and I talked about how I like to get that first programme sewn into the contract. So it's been accepted. There aren't then any arguments trying to get it accepted because the programme is so critical through the project. So if the first programme is sewn into the contract, that's fine. If it isn't, then the contractor has to submit the first programme once the contract has been executed, submits it to the project manager for approval. If the contractor forgets to do that, then as it says there, the employer stroke client can deduct 25% of anything that is due to it. Now, in reality, what's going to happen here is contractor forgets to submit the first programme, payment application's made, the sums are assessed, the 25% is deducted, contractor or whoever didn't submit the programme realises what's happened and quickly submits it. So the next payment application, the 25% should be added back in. So it's just a sort of temporary loss. But of course, it's not a great start to a project, particularly if you're responsible for submitting programmes. The last point, so the final bullet point, is an amendment that's just been introduced with NEC 4. So we'll cover that in a few weeks, but it's about these deeming provisions. If the project manager fails to accept or reject that first programme when it's submitted, so this assumes again that the programme hasn't been sewn into the contract, hasn't been incorporated. If the project manager fails to respond by either accepting or rejecting the programme within the 2 weeks set out in the contract, then the contractor can write to the project manager, give them a further 2 weeks, and if the project manager still doesn't within that further 2 weeks accept or reject, then the project manager is deemed to have accepted. So that's NEC 4 clause 31.3. So do use that clause because, you know, if nothing else, it should at least push the project manager to, you know, come to a decision and notify the decision. And if they don't, then it's deemed accepted and you can progress the programme for the rest of the project. So I think next slide, please. I think that's everything. Yep. So happy to answer any questions.